Welcome to Constitutional Truth. I'm your host, Shar, and I'm going to talk about the Federal House Resolution, House Bill, whatever, H.R. 1, the For the People Act of 2021, which is not even for the people. Normally, I would go through the actual bill, but this bill is nearly 800 pages. There's no way I would put you guys through that. So instead, went through and located the Heritage Foundation fact sheet that they put together. There's a lot of articles out on it that you can pull up and read. I think Vox did one that's actually pretty good, considering it's Vox. But they actually put together a good one, and Tim Pool covered that one. But I'm going to use the Heritage Foundation, and we'll go through it together. I know we've seen Nancy Pelosi and some of her Democrats out in front of Congress on the steps there, talking about how great it is and they're talking ugly about the states that are already filing legislation to push back on it. But there's some reasons, very good reasons why, and we'll get into it because this is constitutional truth, and so we're going to talk about the constitutionality or unconstitutionality of this bill. But let's look at it here. Okay, so the summary here from the Heritage Foundation is that H.R. 1 would federalize and micromanage the election process administered by the states, imposing unnecessary, unwise, and unconstitutional mandates on the states, and reversing the decentralization of the American election process, which is essential to the protection of our liberty and freedom. It would, among other things, implement nationwide the worst changes in election rules that occurred during the 2020 election, go even further in eroding and eliminating basic security protocols that states have in place, and interfere with the ability of states and their citizens to determine the qualifications and eligibility of voters, ensure the accuracy of voter registration rolls, secure the fairness and integrity of elections, and participate and speak freely in the political process. Much of what has been reported in the media, both print and on television, has spoken mostly about what is considered the good things. And this Heritage Foundation paper here goes into the more insidious aspects of the bill. And boy, oh boy, there are some insidious things. So the key takeaways are that H.R. 1 would federalize and micromanage the election process, imposing unnecessary, unwise, and unconstitutional mandates on the states. It would reverse the decentralization of the American election process, an essential protection of our liberty and freedom, and it would implement nationwide the worst changes in election rules that occurred in 2020 and further damage or eliminate basic security protocols. Something that we need to remember and keep in mind is that there's more to elections than just the federal level. We have local elections, county elections, state elections. Then of course, at the local level, we have referendums. We have to choose bond issues. And if we implement H.R. 1 all the way down to the local level, it can have very, very detrimental effects on how people can speak out against things that will affect them financially for 10, 20, 30 years down the road. So let's dig into this. I'm not going to reread this first paragraph because it basically says the same thing we read before. So what H.R. 1 would do is to seize the authority of states to regulate voter registration and the voting process by forcing states to implement early voting, automatic voter registration, same-day registration, online voter registration, and no-fault absentee balloting. Now, early voting isn't always a problem. We have early voting here in Texas. It's not always a problem. However, as we discovered during the 2020 election, when it was learned by a lot of people that President Biden and his son, or his son rather, had been engaged in less than above board business dealings in Ukraine, and that President Biden had told Ukraine when he was vice president that they would not be receiving foreign aid from the United States unless they were to fire the equivalent of the AG that was investigating the company Burisma that Hunter Biden worked for. There were voters who had cast their ballots for Mr. Biden during early voting, but wanted to. I mean, there was literally people Googling, "Can I change my vote?" So this is an issue when you consider that leading up to Election Day, there may be information that a candidate puts out, positive or negative, okay, that can affect the electors, okay, and I don't mean the Electoral College electors. Some states call them electors, others call them voters. I'll just say voters. So voters need every bit of information. And campaigning does not end until Election Day. So if you demand early voting as a means of allowing all voters an opportunity to vote, which again isn't necessarily a bad thing, it can have a detrimental effect if something that would have changed their mind one way or the other, positive or negative, about one candidate or another, that comes out after early voting. Okay, and then the automatic voter registration is obviously a problem because this is an opt-out, not an opt-in situation where everyone is registered to vote. Excuse me. Same-day registration obviously is an issue because then the registrar of elections can't verify if someone is eligible to vote. Online voter registration, well, I mean, that's just a recipe for disaster because anyone, any group, any whatever can go in and do mass registrations, not to mention the fact that there is no such thing as a secure online system. We learned this year with the Solar Winds software that was hacked, and the majority of their clients were governmental. And then, of course, no-fault absentee balloting. What that means is that is basically universal mail-in balloting. States can't say you have to be over a certain age or homebound or living overseas in order to have an absentee ballot. It means that anyone for any reason can request an absentee ballot. HR 1 would make it easier to commit fraud and promote chaos at the polls through the same-day registration, as election officials would have no time to verify the accuracy of voter registration information and the eligibility of an individual to vote, and could not anticipate the number of ballots and precinct workers that would be needed at specific polling locations. It would hurt voter turnout through the 15 days of mandated early voting by diffusing the intensity of get out the vote efforts. It would raise the cost of campaigns. Voters who vote early don't have the same information as those who vote on election day, missing late breaking developments that could affect their choices. It would degrade the accuracy of registration lists by requiring states to automatically register all individuals as opposed to just citizens from state and federal databases such as state departments of motor vehicles, corrections and welfare offices, and federal agencies such as Social Security Administration, the Department of Labor, the Federal Bureau of Prisons, and the Centers for Medicare and Medicaid Services of the Department of Health and Human Services. This would register large numbers of ineligible voters, including aliens, and cause multiple or duplicate registrations of the same individuals and put federal agencies in charge of determining a person's domicile for voting purposes, as well as that individual's taxing state. It constitutes a recipe for massive voter registration fraud by hackers and cybercriminals through online voter registration that is not tied to an existing state record, such as a driver's license. It would make it a criminal offense for state officials to reject a voter registration application, even when it is rejected under the color of law, because the official believes the individual is ineligible to vote. It would also require states to allow 16-year-olds and 17-year-olds to register, and when combined with a ban on voter ID and restrictions on the ability to challenge the voter's eligibility, this would effectively ensure that underage individuals could vote with impunity. It would require states to count ballots cast by voters outside of their assigned precincts, overriding the precinct system used by almost all states that allows election officials to monitor votes, staff polling places, provide enough balance, and prevent election fraud. It would mandate no-fault absentee ballots, which are the tool of choice for vote thieves. It would ban witness signature or notarization requirements for absentee ballots, force states to accept absentee ballots received up to 10 days after Election Day, as long as they are postmarked by Election Day, and require states to allow vote trafficking or vote harvesting so that any third parties, including campaign staffers and political consultants, can pick up and deliver absentee ballots. It would prevent election officials from checking the eligibility and qualifications of voters and removing ineligible voters. This includes restrictions on using the U.S. Postal Service's National Change of Address system to verify the addresses of registered voters, participating in state programs that compare voter registration lists to detect individuals registered in multiple states, or ever removing registrants due to a failure to vote no matter how much time has elapsed. It would also substantially limit the public release of voter registration information, making it almost impossible for nonpartisan organizations to verify the accuracy of registration rolls, and prohibit states from using undeliverable election mail as a basis for challenging a registrant's eligibility. Anyone who followed the shenanigans of the 2020 election will recognize the seriousness of this right here. It would ban state voter ID laws by forcing states to allow individuals to vote without an ID and merely signing a statement in which they claim they are who they say they are. This is absolute, complete, and total, utter insanity. Excuse me. I cannot for the life of me understand why voter ID is such a contentious issue. I am so tired of the old trope of voter ID is voter suppression, and that certain races or members of society have more difficulty in obtaining ID than others. For heaven's sake, you have to have an ID card to borrow a book from the library. You have to have an ID card to fly on an airplane, to take a Greyhound bus, to use the Amtrak. You have to have an ID to get utilities, to rent an apartment or a house, to buy a house, to buy a car, to buy tobacco, to buy alcohol, to get into a nightclub. You have to have an ID in order to get medical care, unless it's an absolute life or death emergency. There is practically nothing in life that does not require an ID. You need an ID to cash a check. You need an ID to open a bank account. There, if you get locked out of your email or your social media, many of them require you to provide an ID to prove you are who you are. So why in the hell is asking for ID to prove that you are who you are to cast a ballot so oppressive? This argument, this tired argument that certain sectors of society are oppressed and suppressed and unable to get an ID, implies that there should be an enormous number of people homeless on the streets, without electricity, without the ability to borrow books, without the ability to purchase alcohol, without the ability to fly, take a bus, take the Amtrak, and all this other crap. And that is an absolute, complete, and total bullshit lie. There are states like Nevada that allow homeless people to vote. I presume that those homeless people show them some form of ID to do so. Anyway, it would violate the First Amendment with respect to a vast range of legal activity. Voter intimidation or coercion that prevents someone from registering or voting is already a federal crime under the Voting Rights Act and the National Voter Registration Act. But H.R. 1 would add a provision criminalizing hindering, interfering, or preventing anyone from registering or voting, which is so vague and so broad that it could prevent providing any information to election officials about the ineligibility of an individual, such as an applicant not being a U.S. citizen. It would expand regulation and government censorship of campaigns and political activity and speech, including online and policy-related speech. H.R. 1 would impose onerous legal and administrative compliance burdens and costs on candidates, citizens, civics groups, unions, corporations, and nonprofits. Many of these provisions violate the First Amendment, protect incumbents, and reduce the accountability of politicians to the public. Its onerous disclosure requirements for nonprofit organizations would subject their members and donors to intimidation and harassment, the modern equivalent of the type of disclosure requirements that SCOTUS and NAACP versus Alabama from 1958 held violated associational rights protected by the 14th Amendment. H.R. 1 would reduce the number of Federal Election Commission members from 6 to 5, which would allow the political party with 3 seats to control the commission and engage in partisan enforcement activities. It would prohibit state election officials from participating in federal elections and impose numerous other ethics rules that are unconstitutional or unfairly restrict political activity, eliminating the ability of the residents of specific states to make their own decisions about what rules should govern their state government officials. It would require states to restore the ability of felons to vote the moment they are out of prison, regardless of uncompleted parole, probation, or restitution requirements. Section 2 of the 14th Amendment gives states the constitutional authority to decide when felons who committed crimes against their fellow citizens may vote again. Congress cannot override a constitutional amendment with a statute. It would transfer the right to draw congressional districts from state legislatures to independent commissions whose members are unaccountable to voters. H.R. 1 would make it a violation of federal law to engage in partisan redistricting and mandate the inclusion of alien population, both legal and illegal, in all redistricting. This is an anti-democratic, unconstitutional measure that would take away the ability of the citizens of a state to make their own decisions about redistricting. It would authorize the IRS to engage in partisan activity. H.R. 1 would permit the IRS to investigate and consider the political and policy positions of nonprofits before granting tax-exempt status, thus enabling the IRS officials to target organizations engaging in First Amendment activity with disfavored views. It would limit access to federal courts for anyone challenging H.R. 1. Now, this is absolutely heinous. The bill would prohibit the filing of any lawsuits challenging the constitutionality of H.R. 1 anywhere except in the District Court for the District of Columbia. And it would allow the court to order all plaintiffs and interveners, regardless of their number, such as all 50 states, to file joint papers or to be represented by a single attorney at oral argument, severely limiting the legal representation and due process rights of challengers. It would establish a commission to protect democratic institutions that would threaten the independence of the judiciary. This is even more disgusting. H.R. 1 defines democratic institutions as those that are essential to ensuring an independent judiciary, free and fair elections, and the rule of law. The commission would be given the authority to compel judges to testify and justify their legal decisions, threatening their independent judgment and subjecting them to political pressure and harassment. These last two items alone are reason enough for the Senate to toss this bill out on its ass and to tell the House to go pound sand. This is not for the people at all. This is for the feds to come in and say, fuck you all, we're in charge, and we will be forever. Now, under Article 1, Section 4, Clause 1, the times, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators, which was amended by the 17th Amendment. This was hotly debated, by the way. So let's look at the Federal Farmer number 3, which is in the Anti-Federalist Papers. One of the Federalist Papers and the Anti-Federalist Papers were the written debates during the time period after the Constitution was written and before it was fully ratified. So let's look at Federal Farmer number 3. The branches of the legislature are essential parts of the fundamental compact. The compact is another word for Constitution. Excuse me. And ought to be so fixed by the people that the legislature cannot alter itself by modifying the elections of its own members. This, by a part of Article 1, Section 4, the general legislature may do. It may evidently so regulate elections as to secure the choice of any particular description of men. It may make the whole state one district, make the capital, or any places in the state, the place or places of election. It may declare that the 5 men, or whatever the number may be the state may choose, who shall have the most votes shall be considered as chosen. In this case, it is easy to perceive how the people who live scattered in the inland towns will bestow their votes on different men, and how a few men in a city in any order or profession may unite and place any 5 men they please, highest among those that may be voted for, and all this may be done constitutionally and by those silent operations which are not immediately perceived by the people in general. I know it is urged that the general legislature will be disposed to regulate elections on fair and just principles. This may be true. Good men will generally govern well with almost any constitution. But why, in laying the foundation of the social system, need we unnecessarily leave a door open to improper regulations? This is a very general and unguarded clause, and many evils may flow from that part which authorizes the Congress to regulate elections. Were it omitted, the regulations of elections would be solely in the respective states where the people are substantially represented and where the elections ought to be regulated, otherwise to secure a representation from all parts of the community and making the Constitution, we ought to provide for dividing each state into a proper number of districts and for confining the electors in each district to those choice of some men who shall have a permanent interest and residence in it, and also for this essential object, that the representative elected shall have a majority of the votes of those electors who shall attend and give their votes. Federal farmer knew what might happen, and guess what's happening? Vox Populi #1 weighed in on this. By this clause, the time, place, and manner of choosing representatives is wholly at the disposal of Congress. Why the convention, who formed the proposed Constitution, wished to invest Congress with such a power, I am by no means capable of saying. Or why the good people of this Commonwealth should delegate such a power to them is no less hard to determine. But as the subject is open for discussion, I shall make a little free inquiry into the matter. And first, what national advantage is there to be acquired by giving them such a power? The only advantage which I have heard proposed by it is to prevent a partial representation of the several states in Congress. For if the time, manner, and place were left wholly in the hands of the state legislatures, it is probable they would not make provision by appointing time, manner, and place for election, in which case there could be no election, and consequently the federal government weakened. But this provision is by no means sufficient to prevent an evil of that nature. For will any reasonable man suppose that when the legislature of any state who are annually chosen are so corrupt as to break through that government which they have formed and refuse to appoint time, place, and manner of choosing representatives? I say, can any person suppose that a state so corrupt would not be full as likely to neglect or even refuse to choose representatives at the time and place and in the manner prescribed by Congress? Surely they would. So it could answer no good national purpose in that account, and I have not heard any other national advantage proposed thereby. We will now proceed in the next place to consider why the people of this Commonwealth should vest Congress with such a power. No one proposes that it would be any advantage to the people of this state. Therefore, it must be considered as a matter of indifference, except there is an opportunity for its operating to their disadvantage, in which case I conceive it ought to be disapprobated. Whether there is danger of its operating to the good people's disadvantage shall now be the subject of our inquiry. Supposing Congress should direct that the representatives of this Commonwealth should be chosen all in one town, Boston for instance, on the first day of March, would not that be a very injurious institution to the good people of this Commonwealth? Would not there be at least 9/10 of the landed interest of this Commonwealth entirely unrepresented? Surely one may reasonably imagine there would. What, then, would be the case if Congress should think proper to direct that the elections should be held at the northwest, southwest, or northeast part of the state, the last day of March? How many electors would there attend the business? And is it a little remarkable that any gentleman should suppose that Congress could possibly be in any measure as good judges of the time, place, and manner of elections as the legislatures of the several respective states? You see, my friends, this is a very dangerous clause and authority given to Congress. And those are just two of the many Okay, there were 20. 20 items wherein the framers debated this issue. This authority should remain in the hands of the states. And as we saw with the federal farmer and with Vox Populi, some of the framers, some of the attendees of the Constitutional Convention were quite concerned with what might happen with too much authority vested in the federal Congress. Now let's look at the authority that Congress has with regard to the president. Article 2, Section 1, Clause 4. I'm sorry, I'm going to scroll up. Article 2, Section 1, Clause 2. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. So here, the states have sole authority over choosing the members of the Electoral College. Clause 3 lays out the process for the Electoral College. Clause 4, the Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. That's the only authority that Congress has with regard to the president and vice president. So they don't get to say anything else on that. They don't get to tell the states you have to use unlimited absentee balloting and no ID and this, that, and the other. Because if the state legislature says that we're going to go back to the legislature choosing the Electoral College members like it used to be, then they would be fully within their rights under Clause 2. Or if they were to say that only people who own real property and or a business can participate in electing members of the Electoral College, they would again be within their rights, because it clearly states, each state shall appoint in such manner as the legislature thereof may direct the members of the Electoral College. And there's nothing Congress can do about that. Now, there are a few excuse me, there are a few amendments to the Constitution that affect voting. And some people have argued with me on social media about this because, of course, this is all over social media and various news groups, pages for news outlets. They like to pull up the 15th Amendment, but I'd like to mention the 10th Amendment first, that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. So I just showed you all the parts in the Constitution that deal with voting specifically. So, other than the upcoming amendments 15, 15, 19, 24, and 26 are the ones I'm going to be showing you. So, other than that, there's nothing else really that Congress can do. They cannot come in and tell the states, you can't keep your voter rolls clean. You have to enroll everyone in your, and make them opt out if they don't want to be registered. You can't do, this, that, everything that we discussed from the Heritage Foundation. Okay? That is wholly and completely unconstitutional, as the Heritage Foundation pointed out. So let's come down here to the 15th Amendment, which came to pass after the 13th, or at the same time, as the 13th and 14th Amendment. And all of these amendments have the same thing in common. They have two parts. Although I believe it's the 19th that doesn't say section 1 and 2, but I'm not even going to, we'll see it. So, the 15th Amendment, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Okay? And Section 2, the Congress shall have the power to enforce this article by appropriate legislation. Race, color, previous condition of servitude. It's been 150-ish years since slavery came to an end. This was ratified February 3rd, 1870. So it's been 150-ish years. Okay. 151 if you, in some days if you want to be technical about it. But so I don't think we currently have anybody that falls under the previous condition of servitude. But we definitely have race and color. And there's not a single law in any of the 50 states, in any of the territories where voting is allowed, that denies or abridges anyone's right to vote based on race or color. None. At all. Period. And in fact, Congress has enforced this amendment appropriately with the Voting Rights Act. I want to say of 63, but don't quote me on that. Okay? Now we come down to Amendment 19. Ratified August 18, 1920. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex. Congress shall have the power to enforce this article by appropriate legislation. This is what we call the Women's Right to Vote Amendment. Although historically women did have the right to vote in many states prior to 1920, it maybe not all states, but there were plenty of states that had women voting. I mentioned the landowner or property owner or, real property or business owner. There were many states that recognized the right of women to vote if they owned property or a business. So, but yes, this was that one. Okay, the suffragette movement. And are you noticing that this second clause is exactly the same as the previous one? Appropriate legislation. Okay. Now we're going to come down to 24. The right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay poll tax or other tax. That's the operative clause there. It's talking about POTUS and VPOTUS. It's talking about federal elections for failure to pay a poll tax or any other tax. And this one was ratified in 1964. And it was a big one because at that time, during the Civil Rights Movement, black citizens predominantly were charged a poll tax. They were told they had to pay a tax in order to vote. So this came around. And look at Section 2. The Congress shall have power to enforce this article by appropriate legislation. If they're trying to argue that getting an ID is a poll tax, that is utterly ridiculous because there are so many other things in life that require an ID. And I don't know of any place that requires a distinctively different ID to vote other than a driver's license or a state-issued ID or some government-issued ID. So if you drive, you have a driver's license. If you need to cash a check or have access to health care or whatever else it is, access to federal or state benefits, you have to have an ID. So you have an ID. There's not many people that don't have an ID unless they're a child. And then down here is the 26th Amendment that came out in 1971. And it was the right of the citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged on account of age. And again, the same exact section. So, 18 years of age or older. How is it that H.R. 1 wants the states to register 16 and 17-year-olds automatically when this right here clearly states 18 years of age or older? They're trying to rewrite the 26th Amendment via statute. So anyway, here's the bill. They call it the For the People Act of 2021. It has passed the House. I will place a link to it in the description. You're free to download it and read it. I would just strongly suggest that you go to congress.gov and, set up an account where you can, get alerts. There we go. Where you can set it up to get alerts so that you can keep up with the actions on these bills. This one is really important. We need to know what's going to go on with it in the Senate. The Senate has so many things that it's dealing with right now because the House just keeps passing bill after bill after bill and shoving it up there at the Senate. So, and as usual, if you appreciate what I'm doing and would like to support it, be sure to like the video, subscribe to the channel, share the video, and please leave a comment. Thank you so much for your time today, and I hope that you all have a wonderful rest of your week. Thank you so much.